Committee on Judiciary and Hawaiian Affairs called to order. It's Wednesday, February 23rd, 2022, 2 p.m. And we have a number of bills on the list. The first is HB 1768. Vice Chair.
Yep. HB 7068, HD2, relating to the disposition of water rights. First, we have the Department of Hawaiian Homelands in support.
Aloha, Chair Nakashima, Vice Chair Matsuyoshi, members of the committee. Tyler Goins, Deputy Director for the Department of Hawaiian Homelands. Chairman Ayla is presently in the Hawaiian Homes Commission meeting. We'll be standing on our written testimony in support of this bill.
And Tyler, you're coming through a little soft, but we understand that you'll stand on your testimony.
That's right. Thank you.
Okay, thank you. Next up, we have, oh, and I'm sorry, I forgot to announce, for all those testifying, please try to limit your comments to 2 minutes out of respect for the other testifiers. And if you are not currently testifying, then please turn your video off. Next up, we have DLNR with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Ian Hirokawa with DLNR Land Division. Department supports the intent of this measure, but offers an amendment in our testimony, and just highlight 2 points. One is because we believe that an exemption should, even though we would exempt the water leases for taro cultivation from what we would consider the most onerous parts of the leasing process, which is the public auction. We still believe that they should a formal disposition is in the best interest of both the state and the taro farmer. So we would like to still retain that, also to retain the DHHL beneficiary consultation and watershed management requirements, because again, they're not very onerous. We're trying to push for or support a limited exemption to address the most difficult and burdensome requirements in the leasing process, and be available for any questions. Thank you.
Okay, thank you. Next up, we have County of Hawaii, the County Council in support.
Aloha, awina lao kākou. My name is Holeka Inaba. I serve on the Hawaii County Council representing District 8 North Kona. I want to stand on my written support and also express my mahalo to Kapua Sprott and Uilani Tanigawa Lam for all of their efforts in getting our Wai'oli farmers, and hopefully this is the first step, but it's an important step to further support of traditional practices and customary rights here across Hawaii. Mahalo nui.
Okay, thank you. And speaking of them, the Waiho'ole Valley Taro Hui in support.
Aloha, Chair, Vice Chair, Honorable Committee members. I'm Kapua Sprott, and I'm here testifying today on behalf of the Wai'ole Valley Taro Hui. We appeared before your committee last session on resos on a similar topic, and so I will just summarize very briefly. I'm a professor at UH Manoa's Richardson School of Law, the director of our Native Hawaiian Law Center, and I co-teach our Native Hawaiian Rights and Environmental Law clinics. And since 2019, U'i Tanigawa Lam and I have had the great privilege of working with the farmers from Wai'ole Valley, navigating the incredibly complex water leasing process under HRS Chapter 171. Their situation is detailed in the Hui's written testimony, as well as the testimonies of 11 individual farmers upon which we stand. But for those who are less familiar, the Hui is a collective of about a dozen small family farmers, many of whom are Native Hawaiian, long-standing ties to this area, like third, fifth generation kalo farmers, some of whom were born on the farms that they now tend. In the wake of the 2018 floods, both the North Shore and these farms in particular were just devastated. And as a result of the disaster recovery process, they were informed that they would need permitting or exemptions, including from HRS 171. So over 3 years, the farmers, with the assistance of our clinics, have been working diligently to comply with 171's complex requirements. I mean, everything from interim in-stream flow standard amendment, DHHL consultation, which is complete, final EA, FONSI, and more. So over this time, more than 30 students and 4 attorneys have spent more than 2,000 hours on this process, and we're not POW yet. And so we are here today to ask for your support of this exemption. We believe that the Hui's special status and their long-standing ties to this area, they have been stewarding these specific lo'i kalo for literally centuries, warrants this exemption. Despite the justice issues here, these farmers have dutifully sought to comply with the full letter of the law. And while we did not ask for this bill, the farmers and I are grateful for it and we welcome it. In particular, I want to mahalo the chair, the vice chair, and the many other co-sponsors here, Reps Nakamura, Ichiyama, Lopresti, for recognizing the need and really working to help us find a solution. We have worked closely with Ian. We recognize his concerns. And in fact, I spoke with him at length yesterday. And I do want to highlight that while we appreciate DLNR's concerns about DHHL, DHHL does support this measure, as is evidenced by the deputy director's testimony today. I would also note that I reached out to the Water
It's
Commission.
been 2 minutes. If you could start to conclude your testimony, please.
Okay, I'll just conclude by saying we appreciate your time and we're happy to answer any questions that you may have. Mahalo.
Okay, thank you. And Joanne, I see you on. Well, why don't you go? Go ahead.
Aloha, my name is Joanne Kaona. Mahalo for this opportunity to testify. I'm here to humbly ask that you please support HB 1768. And I want to mahalo Representative Nakamura, Nakashima, Matayoshi, Chiyama, and Lopresti. I'm the secretary of the Waioli Valley Tarahui, and I also help my dad, Clarence Shorty Kaona, farm kalo in Waioli. And it's very important to our ohana, and as a fourth generation farmer, of course, I want to continue this legacy, but it's been pretty tough, especially after the 2018 floods and navigating this 171 water lease. We couldn't have done it without all this legal support from Kapua and Ui and all the students that have helped us. And we've even had so much support from representatives, senators, and but still with all this support 4 years later, we still don't have a water lease. And that's why I think this bill is important to us. And because we just want to continue our cultural practice of farming kalo, and we don't think it should have to be this hard to get there. Mahalo, please support this bill.
Okay, thank you. And we have one more member of the Waioli Valley Tarahui, Chris Kobayashi. Are you on? Okay, please proceed.
Aloha, my name is Chris Kobayashi. I'm a third generation kalo farmer in Waioli, and I'm also a member of Waioli Valley Tarahui. And you've heard already from Kapua Sprout how many hours that she and Ui, Lum, and their clinicians have spent on behalf of us to get to this point. And so, I mean, you've already heard numerous times how it's in order to grow kalo these days, how a farmer needs to be a lawyer too. I just wanted to say and reiterate that our families and other ancestors have maintained the system for generations, even way before the floods. I would like to say that I think that this exemption is actually a win-win for both the LNR and our kalo hui. And the reason I say this is that our hui goes up once a month, minimal, to do maintenance, using power tools, hand tools to keep the awai, the banks clean, you know, take down trees. There's zillions of albizia growing up there, trying to keep those back. And we go up as needed on emergencies, you know, like if there's a big rain. And, you know, we know that nature doesn't stop her work, so we have to do the regular maintenance. And we farmers of Waioli, we need this water. So it's automatic that we're going to take care of it. So my query is to DLNR, if we don't do the regular maintenance, will they be able to do it? Will they have the funding to do this constant maintenance on state conservation land? So, and also I want to say how proud I am that Joanne is here, because she represents one of the younger farmers and women in our hui. And it just makes me feel relieved that we're going to have kalo continue to grow with that kind of commitment. So mahalo to the chair, vice chair, Representative Nakamura and Ichiyama and Lopresti for helping to introduce this bill. Please support this exemption. Mahalo.
Okay, thank you. Next up, we have the Council for Native Hawaiian Advancement and Support. They have late testimony. Kuhio Lewis, are you on? Okay, guess not. Next up, we have members. We have a number of individuals testifying, submitting written testimony in support. Two of them here today, I hope. Sierra Lynn Stone, are you here?
Wait, Senator, hold on. I don't know if they're calling me. Hold on.
Sierra Lindstone, are you here? I do not think that was her. All right, Huilani Lum, are you here?
Aloha, I'm here. Aloha mai kako, chair, vice chair, and committee members. My name is Ui Tanigawa Lam, and I'm an attorney and a fellow at Kahuliao Center for Excellence in Native Hawaiian Law, where I have the privilege of helping to co-teach the Native Hawaiian Environmental Law clinics. Mahalo nui for this opportunity to testify in strong support of this measure. You have my written testimony, but I'd like to briefly highlight here that I believe this measure takes steps to bring the Black letter law to life on the ground in our communities and protects the practices that make Hawaii home. So it would provide much needed justice and kokua for hardworking kalo farmers like the Wai'oli Valley Tarahui. While I'm grateful to know these incredible folks, I think that they shouldn't need a lawyer to be a farmer. I have seen firsthand the Hui's 2021 final EA that confirmed that in-stream use of water for traditional and customary kalo cultivation like the Hui's offers significant environmental benefits. And that analysis supports the idea that kalo farmers like those in Wai'oli actually improve the environment and provide crucial stewardship of Aina and its resources. That said, I know you all have a busy day ahead of you, so mahalo nui for your service and work for collective Hawaii, and I respectfully ask you to vote today to pass this bill. Mahalo nui.
Thank you, members. That's the last testifier we have today. Any questions? Rep. Nakamura.
Thank you. I have a question for Professor Sproat. Hi, Kapua. My question has to do with the DLNR testimony regarding the Hawaii DHHL review. You mentioned in your testimony that DHHL, you did go through the review process. Is this proposed amendment necessary?
Thank you for your question, Rep. Nakamura. You know, I looked at DLNR's testimony. I also spoke to Ian at length yesterday, and I understand his concern, but we respectfully disagree on this. And I'd also note that, again, DHHL is here today and has consistently submitted testimony in support of this specific exemption in both vehicles, moving in both the House and the Senate. And so I don't think it's an issue. I don't believe DHHL thinks it's an issue. I also followed up yesterday with the Water Commission deputy, which is an entity within the Department of Land and Natural Resources that is charged with implementing and adopting these reservations for the Department of Hawaiian Homelands. And the Water Commission is confident that they can address these issues through the reservation process and also through the interim in-stream flow standard amendment process that would be implicated. And so I don't believe that DLNR's requested further amendments are necessary, but mahalo.
Thank you. Chair, I have a follow-up question for DHHL, but I can do that at a later time.
And members, any other questions? Otherwise, Rep. Nakamura is going to go one more time. Okay, go ahead, Rep. Nakamura.
Hi, Deputy Director. Wanted to ask you, because many of these applications will require interim in-stream flow standard that requires DHHL consultation. Is it necessary to have a separate process aside from that to ensure DHHL is consulted?
I don't believe so, no. I think as the bill's written, I think it's sufficient. The commission has also agreed, and based on our longstanding engagement with Kahuliao, Kapua, and everyone involved, I think at this point, DHHL is satisfied that as written, it's fine, and the proposed amendment isn't particularly necessary.
Thank you very much.
Okay, thank you. Members, any further questions? Okay, seeing none, we'll move on to HB 2084 HD2 relating to important agricultural lands. First up, we have the Department of Agriculture in support.
Aloha Chair, Vice Chair, members of the committee, Phyllis Shimopokoro Geyser, Chairperson, Hawaii Department of Agriculture. We stand on our written testimony supporting the measure and deferring to Office of Planning Sustainable Development. Mahalo.
Okay. Speaking of them, they are up next. Office of Planning and Sustainable Development in support.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Ruby Edwards. I'm testifying on behalf of not only the Office of Planning and Sustainable Development, but also the Director of the Department of Business, Economic Development and Tourism. We stand on our support of our written testimony, noting our concerns and requests for further amendments.
Okay, thank you. I have two other testifiers, both from the Department of Agriculture. I've got Earl Yamamoto and Morris Atta, but we've already heard from the Department of Agriculture. Phyllis, is that it from you guys, or did someone else want to speak?
They're available both to answer any questions.
Okay.
Thank you.
And just a note, DLNR always submits about three or four of the same testimony. You guys just need to submit one. Just clutters everything up. All right, that is all the testifiers we have here today. Members, any questions? Okay, seeing none, we'll move on to HB 2169 HD1 relating to the Comprehensive Offender Reentry System. First up, Public Defender's Office in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm James Tabe with the Public Defender's Office. We do support this bill, but we do agree with the other testifiers in support that on page 2 from lines 9 through 11, putting the onus on the inmate is wrong. The onus should be on public safety to initiate the process. Other than that, we would stand on our written testimony in support. Thank you. And I am available for questions later.
Thank you. Next up, Department of Public Safety in support.
Hi, good afternoon, Chair, Vice Chair, members of the committee. Max Otani, Department of Public Safety. We'll stand on our written testimony in support of this measure and would be available for any comments or questions you may have. Thank you.
Okay, thank you. Next up, Common Cause Hawaii with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We have comments on this measure, HB 2169 HD1. Common Cause proactively supports proactively providing assistance to incarcerated individuals and procuring civil identification to transition back into society. Our concern or question really has to do with how automatic voter registration will interact with this procuring of civil identification. AVR was passed last session in 2021, and it also interfaces with civil identification, in that if you seek a civil identification, a state ID, then automatic voter registration should be provided with that as well. So that was just really our comment that we don't know how it ties in together with this process. Thank you for allowing us to comment on this measure, and I'm available for any questions. Thank you.
Yeah, thank you. Next up, Community Alliance on Prisons in support.
Aloha, Chair Matayoshi. Kat Brady testifying on behalf of Community Alliance on Prisons. Of course, we support giving ID to people who are exiting incarceration. ID is absolutely crucial to be in the community, to open up a bank account, get a library card, find work, find a place to live. ID is absolutely crucial. Our problem with this bill is what the PD suggested, which was on page 2, lines 9 to 11, that says, provided the inmate asks for assistance. No, this is the responsibility of the Department of Public Safety. They release people. They are supposed to release people into the community who can actually be successful. Releasing people with no money, no ID is a recipe for recidivism. So please, we implore you to remove that one phrase on page 2 to make the bill work. Mahalo.
And last up, we have ACLU of Hawaii with comments.
Aloha Chair Nakashima, Vice Chair Matayoshi, committee members. My name is Carrie-Ann Shirota. I'm testifying on behalf of the ACLU of Hawaii. We offer comments on HB 2169 HD1. As you're aware, the ACLU is committed to transforming our criminal legal system and building a new vision of safety and justice. Our foremost strategy is decarceration, reducing the number of men and women in our jails and prisons, predominantly Native Hawaiians and other people of color. At the same time, we advocate for humane conditions and preparing people to transition back to their families and our community. The U.S. Department of Justice has recognized that the provision of civil identification documents is being critical to successful reentry. This is some of the context in which this has come about. Since 2017, the Department of Public Safety has been statutorily mandated to provide comprehensive reentry planning and to issue civil identification documents to people exiting jails and prisons. By their own reports, this was from their own report from the Reentry Coordination Office in 2018 and 2019, that more than half of people exiting jails and prisons left without state identification cards. The failure to do so contributes to recidivism, things like accessing housing, medication, many different benefits in the community. In a letter in May 2020, the former PSC Director Nolan Espinda confirmed that the department had received approvals to use the same vendor as a city and county to purchase the specialized equipment to issue the civil identification. Now, 2 years later, it's puzzling that PSD is submitting testimony to lawmakers requesting to water down the comprehensive law and making what was once mandatory, that they shall issue identification cards, into a less definitive requirement of PSD shall assist inmates. This is backwards. The Oversight Commission has recognized the importance of IDs. They support putting the burden and the responsibility back within the Department of Public Safety, and this is a best practice. So we ask that you ensure that PST's compliance with their legal obligations to provide comprehensive reentry planning, which includes issuance of civil identification. Mahalo for the opportunity to testify.
Thank you. That's the last testifier we have here today. Members, any questions? Rep Ward. Rep Ward, you're muted.
Thank you, Chair. Is public safety still here? Is anyone?
Yes, I am.
Okay, thank you, sir. The question is, well, two questions. Why water it down with they have to ask for it? And then secondly, this seems so commonsensical. Why has it been done before, as a matter of fact? When
your first question, it's upon notifying them that this service is available, that the inmate has a choice to say, yes, I need assistance or not. That's how we read this language here.
But you know, in the society today, it's like saying, hey, do you want to have a name? If you don't have a name, you can't get anything. And if you don't have an ID, you can't get anything with your name. I mean, my point is, it's so common sense. Why would you have to be told to do something is like, hey, put your pants on before you go out into the public? Maybe I'm simplifying it too much, but it seems that commonsensical.
We would need the inmate's cooperation to get the documents needed to, work to get the ID. And if the inmate doesn't want to cooperate and says, no, it's not necessary, we cannot force the inmate to work with us. And that's how we read the language in the last paragraph.
But I think the way you explained it, it would be the opposite, that, hey, if they refuse it, yeah, then you refuse doing it, but versus they got to ask for it. But my point is, why hasn't it been done before?
Well, the other part of this bill is to clarify, it's been a while since this law was passed, and we're very close in getting assistance, let me just go back a little bit. We cannot print IDs, state IDs. That's the bottom line. We get assistance from the Department of Transportation and the county driver's license people to prepare all the documents. We submit the documents to the machine that we recently got, and then the counties will print the IDs, and then we will receive the IDs from them. So we, as the Department of Public Safety, cannot generate our own state IDs.
But you can facilitate their acquisition. I think that's the point.
Now with the current equipment that we recently received, and we'll be able to scan the documents and get those documents electronically to the city, and the city will notify us when the ID cards are ready to pick up.
I hear your argument, but it's like this bill. We're going to micromanage you until you do what otherwise is commonsensical. Thank you for all you do. Thank you, Chair.
Members, any other questions? If not, I want to follow up on one of the questions Rep. Ward just asked for public safety. How many people refuse your help to get an ID? Like just rough percentage estimate.
No, but there are many people that come in.
Yeah, we don't have a rough percentage for you, Vice Chair. I'm sorry.
Is it more than half or less than half?
Well, the release from jail custody, you know, the time in their custody with us when they're in jail, you know, it varies from, you know, a few days or overnight, you know, to a couple of years. So, you know, that wouldn't be a very accurate gauge, but we could go back and look to see how many of them actually.
Well, what percentage have you helped get IDs?
We have that information that I can get to you.
Okay, yeah, if you don't mind getting it to Chair Nakashima, you can distribute it to the committee.
Sure, we will.
Thank you. Members, any other questions? If not, we'll move on to HB 1486 HD1 relating to theft. First up, we have the Office of the Public Defender in opposition.
Good afternoon, Chair, Vice Chair, and committee members. Alan Komagomi, testifying on behalf of the Office of the Public Defender in opposition to HB 1486 HD1, which aims to make theft of motor vehicles, motorcycles, and mopeds all Class B felonies. As it stands now, our penal code has several laws in place designed to criminalize all types of theft, and penalties can range anywhere from 1 year in jail to 20 years in prison, depending on the facts and circumstances of the crime. Penalties for theft can be dependent on the value of the car, motorcycle, or moped, and we feel that this is the proper way to classify theft of property. It should be based on value. What is troubling about this bill is that it includes mopeds in this proposed amendments. Mopeds can value anywhere from a few $100s to a couple $1,000s. Many used mopeds are valued below the felony threshold level of $750, and this proposed bill, if passed, would basically turn misdemeanor conduct into a Class B felony offense. We feel that elevating the penalty to 10 years will do little to deter theft. A person contemplating stealing doesn't usually think before they steal, let alone think about the consequences. I think deterrence is probably better served or better based on chance of getting caught than the actual penalties. If there's a high likelihood the person will get caught, that person will probably be less likely to commit a crime. In my 19 years as a public defender, I cannot say I've ever had a case where a person was caught and prosecuted for stealing a car, motorcycle, or moped. But in cases where that person actually is caught, if this bill were to pass, that person would face a 10-year prison sentence, regardless of the value of the car, motorcycle, or moped, which seems overly harsh when you think of many common instances involving theft. So for those reasons, we oppose this bill. Thank you.
Thank you. Next up, we have County of Hawaii prosecutors in support. Hawaii County Prosecutor's Office. Okay, not here. HPD in support.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Captain Jared Hiromoto of the Honolulu Police Department. HPD is in support of House Bill 1486 HD1, and we stand by our written testimony. Thank you for this opportunity. We'll be standing by for any questions.
Okay, thank you. And members, we also have about 10 individuals, all in support, but none present. Members, any questions? Report. Report, you're muted.
Sorry about that. HPD, please. The captain. The question is, is there any correlation between the amount of fine and the deterrence? One of the testifiers said that the amount of the fine doesn't really deter. What is your experience, or what does the data say at HPD, or what's the line of discussion?
Well, for us, the fines and the penalties, that's essentially more goes towards the prosecution side of the house. But for us, we did see an increase in auto thefts from 2020 to 2021. Obviously, pandemic was in 2020, and we're still in it. But just to see that increase in auto thefts is concerning. So that's why we stand by our testimony, and we agree with the legislature that the findings that's public's concern over increased vehicle thefts leads to a desire for stiffer penalties.
The second part of that is obviously not making crime pay. What is the experience of when we do have fines such as this 10 to 25,000? What is the experience that you actually have received that money? In other words, we could put it up to 50,000, but given what it is now, how many people are really derelict in paying what the fine is right now, whether it's 5 or 10,000 and minor compared to what this is going to jack it up to? In other words, how much in default, regardless of what we set it at, is the experience of your penalties? Who's paying them and who's not paying them? Do you have any percentages?
No, we don't have that kind of information because that falls on usually the areas of the court. So,
is anybody on this call from the court who knows that? Because my sense is if we jack this up so high, nobody's actually going to pay it, and it's going to be useless. Okay, thank you, Captain. Thank you, Vice Chair.
Thank you.
Okay. Members, any other questions? Okay. Hearing none, we'll move on to HB 1860 HD1 relating to catalytic converters. First up, we have the Department of Transportation in support.
Vice Chair.
Nope. Yep. Rep. Tokioka.
Sorry, I thought I was unmuted. I wanted to ask a question about 1486. Sorry.
Yep. Let's go back. Let's go back to 1486 related to theft. Rep. Tokioka.
Okay. Yeah. So I have a question for Mr. Komagome. Is he still on? Oh,
yes.
There you are. Okay. So what you said, which caught my attention, was if you steal a motor vehicle, motorcycle, or moped, that you could be arrested, and the fine doesn't. I mean, the penalty doesn't compensate with the crime. I think that's what you were saying, right? But yes. in section 2 of this bill, number A, I would, the way I read that is that would supersede the amount of a moped if it's a couple $100, because it says, as I read it, the property or services, a value of which exceeds $20,000. Is that not the way you see it?
The way I see it is moped would be under a different subsection. So if you are prosecuted for stealing a moped, it's going to fall under the theft in the first degree statute.
But the part of this bill, yeah, I see the subsection, and I didn't have time to peruse to 291C. But in the same bill, wouldn't the value of the amount stolen have to exceed 20,000?
So I'm just seeing the amendment adding subsection G. It doesn't have any value included. It's just if you steal a car, motorcycle, or moped, it falls under this statute. That's the way I'm reading this bill.
Okay, so what if we added, which exceeded the $20,000 amount, which is what the section or the alphabet A in this bill?
So I mean, I think the theft in the first degree statute as it stands, as it's currently our law, would cover anything over 20,000 under subsection A. So I don't think you would need to include a moped and then include value. So as the law stands right now, if you steal something over $20,000, I believe you can be prosecuted for the crime of theft in the first degree.
Okay.
The problem is if you just include mopeds across the board, if you steal a $200 moped, now you can be prosecuted for theft in the first degree because it covers cars.
Yeah, and I agree with you. I agree with you 100% on that. So that's why I'm trying to figure out a way how, if somebody steals somebody's moped, and I guess theft is on the rise now, as we all know, whether you're the prosecutor or the public defender. We need to try to deter people from doing it, but I see what you're saying. If the moped is $300 and somebody's, going to face that penalty, it doesn't work out. So you're just saying that we don't have to have the motorcycles, the mopeds, and that section in there. It's the crime is the crime and the value is the value in this bill as it exists.
Yeah, I think valuation is the better way to classify the level of offense based on the value of the item stolen.
Okay, so then how would you're just saying just take motorcycles out and leave it as it is. And if somebody steals a moped or a motorcycle, then the crime shouldn't fit the penalty that's in that bill.
Yeah, we believe 10 years for a Class B felony for a moped theft seems overly harsh in most cases.
Okay, thank you. Thank you, Vice Chair.
Thank you. Members, any other questions before we move on? Otherwise, let's move on to HB 1860 HD1 relating to catalytic converters. One more time, Department of Transportation in support. Not here. HPD in support.
Aloha. Chair Nakashima, members, Major Roland Turner with the Honolulu Police Department here because the HPD does support House Bill 1860. We're going to stand on our written testimony in support, and I will be here to answer any questions you have.
Thank you. Honolulu prosecutors in support.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu appearing on behalf of the Honolulu Prosecuting Attorney's Office. We are in support of this bill. We feel it's a good mix of both appropriately penalizing theft of a catalytic converter as a Class C felony, as well as implementing strict record-keeping requirements similar to those used for copper, implemented for copper about 10 to 12 years ago. Available for questions, if any. Thank you.
Okay, thank you. And we have Stolen Stuff Hawaii in support. Okay, not present. Members, we have a number of individuals testifying, mostly in support, one in opposition. Members, any questions?
Here, I have a question. Ward here.
Report.
HPD, briefly, has the incidence of the catalytic converter theft flattened, gone up, or gone down in the last year, or in your recollection when this became a pet thing against Priuses, et cetera?
It's going up, sir.
It's going up. Okay, so the timeliness of this bill is right now, here and now. Thank you very much.
Absolutely.
Thank you, Chair.
Members, any other questions? Okay, seeing none, we'll move on to HB 1434 HD1 relating to the counties. First up, we have DPP in support.
Good afternoon, Chair Nakashima, Vice Chair Marayoshi, Dean Uchida with Department of Planning and Permitting, City and County of Honolulu. We're in strong support of this bill as part of Mayor Blangiardi's legislative package for this year. It addresses a big problem we have in finalizing the last step of going after people who have civil fines and liens placed against their property. Right now, we got to go through the court system, which takes a lot of staff and resources from court counsel, and it's usually low on the priority list. So this would put it on par with what we're doing with real property tax, where you can go to a non-judicial foreclosure proceeding when the lien reach a certain amount. So appreciate your support. We hope that the bill passes through, and happy to answer any questions you might have.
Okay, thank you. And members, we also have written testimony by 2 Honolulu City Council members, both in support. Members, any questions? Okay, seeing none, we'll move on to HB 2042 HD1 relating to solar energy. We have the Hawaii State Energy Office with comments and one individual in opposition, but neither are here to testify today, so we will just keep the train rolling. HB 1891 HD1 relating to the Uniform Recognition and Enforcement of Canadian Domestic Violence Protection Orders Act. First up, the Commission to Promote Uniform Laws in support.
Aloha. Thank you for the opportunity to testify in strong support of this bill. This bill offers tools for police officers to combat domestic violence and help our Canadian visitors. In December 2006, Ingeborg Jandura, 82 years old, from Edmonton, Canada,
Elizabeth, you're breaking up. Maybe you can turn off your video to save some bandwidth. Okay, we might have lost her. Elizabeth, do you mind disconnecting and reconnecting? We'll come back to you if you can hear us.
Sure, thank you. Thank you very much.
Elizabeth, we got pretty much none of your testimony. I think it might be your bandwidth issue. If you could either turn off your video or reconnect. We'll move on though right now to Hawaii Association for Justice with comments. Not here. All right. Elizabeth, have you managed to get your audio working? All right, well, we do have your written comments and support. We'll move on. Well, members, any questions in case she comes back? Report. She may not be able to hear you now. I think she may have logged off.
Chair, I guess this is more for the archive, but I mean, it's great. We're going to help Canadian TROs, et cetera, but then we're going to have Japan and then our bigger visitors from China, then maybe other places. I'm not sure of the context of how the Canadian one will then lead to another role of countries or other kind of TRO, which HPD now is 200 to 300 officers short of vacancies. How this is going to work out, I'm not really sure. So if Elizabeth, you're on, let us know how this is not going to set a precedent for other countries with other difficulties like such as this.
Okay, we're going to monitor if Elizabeth comes back on. If she does, we'll
okay.
circle back.
Thank you, Vice Chair.
You just tried? Okay, yeah, put her through. Elizabeth, can you hear us? Oh wait, she's connecting. Elizabeth, can you hear us?
I can see her.
You're muted, but Rep Ward has a question for you.
Elizabeth, your testimony said how well taken the bill is, but what would we stop at Canada and not go to Japan and other visitor areas like China and Malaysia, Indonesia, etc.? Why would we give Canadians, even though they're our nearest neighbor, does this bill set a precedent, basically, is the question.
Thank you, Rep Ward. That's a really great question. And I wondered the same thing. And I think we have great comfort with the Canadian justice system. And so that's why we're focused on Canada. And if you look at Commissioner Takayama's testimony, he points out that it's reciprocal, that in Canada, they give recognition of our domestic violence orders too.
So this is a reciprocal. It's nothing more than that. We're not reinventing or creating the wheel or whatever.
I don't think we're doing that. And I think I started to talk about Ms. Jandura because that case really touched me. And I think that if we can give police another tool to separate people who are arguing, then we can hopefully prevent something like that happening in the future.
Do we have it with any other countries, what you call now a reciprocal that this bill would fill for Canada?
Not that I am aware of, Representative. We have it within the 50 states, but I'm not aware of us having it with any other countries.
I think domestic violence is a really important thing we want to curtail and curb. But remember, our southern border is opening with other cartels and drug dealers and everybody who gets in with even out a COVID test. That's another issue, but I'm very concerned that we're doing something with Canada and we're ignoring the rest of the 100 or so nations that are invading our country. Thank you, Elizabeth.
Thank you.
Thank you, Vice Chair.
Members, any other questions? If not, let's move on to HB 2208 HD1 relating to sexual abuse of minors. First up, we have the AG's office with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Karen Inagaki, Deputy Attorney General. We have submitted comments and concerns about extending civil statute of limitations for a very long period of time. I am available to answer any questions, and thank you for the opportunity to testify, to provide comments. Thank you.
Okay, thank you. Next up, we have the Hawaii State Commission on the Status of Women in support. Okay, not present. Next up, we have Indigenous Consultants LLC in opposition. Nope, not here. Okay, next up, Talbert Law LLC in opposition. You're muted.
Hello. Aloha, honorable representatives. Before I start the highlighting of written testimony, Mililani Trask has a conflict. She's before OHA because they are considering filling the trustee seat from Hawaii Island. So she apologizes for her inability to be here, but she couldn't clone herself. Anyway, in the time allotted, I will try to give the highlights of her written testimony that she submitted on behalf of Indigenous consultants, as well as that I submitted on behalf of Talbot Law. You do have a written testimony, but in essence, this is our joint thinking. We don't understand, well, there's some basic questions. What is this bill, what problem is this bill trying to solve? Why are we importing almost verbatim California law to solve whatever the problem is? Why are we placing additional burdens and hurdles upon victims? And ultimately, who benefits from doing that? In Mililani's written testimony, she notes from Indigenous consultants that there is an unintended disparate impact that this bill has on the Native Hawaiian Indigenous community. We know by fact that by and large, the majority of plaintiffs that have come forward are children from the Kamehameha schools who were subjected to child sexual abuse as early as the 60s and 70s up to the present. She also has pointed out in her remarks that the impact upon these victims is that they commit suicide, they become drug addicts, they're homeless, and they suffer other horrendous consequences. There is no reported case, so we don't know what the problem is. There's no reported case where any of these cases have been dismissed due to lack of merit or lack of reasonableness, although I'm certain there have been many efforts to do that. Moving on, there are technical aspects. Why is it that both Talbot Law and Mililani Trask through Indigenous consultants oppose this bill? We oppose it because it has a disparate impact on the Hawaiian community. Secondly, there are these burdens and procedural guidelines only victims in child sex abuse cases are required to endure. Let me outline those very quickly. You will find them in E and F. Saying it in language we can all understand, no other tort litigant is required to prove that their case is reasonable and meritorious before they can even serve it on a defendant. No other victim plaintiff is required to have his or her attorneys submit affidavits corroborating facts in the complaint or any effort to amend the complaint. Also, there is a section about DOE defendants. As you all know, when a lawsuit is filed, DOE defendants is used as a place saver. Often, you know, there's somebody out there or there's some company or entity out there that may have contributed to the harm, but you don't know their identities. If discovery reveals identities, then you go back to court and fill that in. This bill requires additional burdens and hurdles that are not found in the rules that all of attorneys and plaintiffs, as well as defendants, are required to follow. In a nutshell, we fully appreciate and fully support the spirit of trying to amend and revise our child support abuse law to allow victims their moment to seek justice. You know, victims of child sex abuse are just—
Ms. Talbert, that's been a bit over 4 minutes.
I'll just finish my sentence.
Thank you.
Victims of child sex abuse ask for a level playing field, nothing more, nothing less. This bill does not do that. Thank you.
Thank you. Next up, we have the Sex Abuse Treatment Center in support.
Good. Sorry. Hold on. Start. Good afternoon, everyone. Lynn Costales on behalf of the Sex Abuse Treatment Center. I submitted written testimony, Chair and Vice Chair, as well as committee members regarding this particular bill. So I stand on that written testimony. We do support the extension of the statute of limitations on civil lawsuits involving child sexual abuse. And we do have some, I guess, comments and reservations with respect to subsection E and F Beyond that, I have nothing more to provide and am here for any questions. Thank you.
Okay, thank you. Next up, we have Child U.S. Advocacy in support.
Thank you, Chairman and committee members, for allowing me to testify in support of HB 2208. I am the Executive Director of Child U.S. Advocacy. I'm also a survivor of child sexual abuse, and I testify all over the country on these matters. By extending the statute of limitations, we will help identify hidden predators and institutions that endanger children. Right now, we know that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday, many sadly, repeatedly. And without accountability in our laws that expose these hidden predators, our children will be at great risk. What's going on across the country right now is that 17 jurisdictions have completely eliminated the statute of limitations for child sexual abuse. 27 jurisdictions have enacted either revival or window legislation, Hawaii being one of those, and 3 jurisdictions have complete open permanent windows. As early as February of this year, 21 states and Congress has introduced new statute of limitation reform for this epidemic. 12 of those states, by the way, have windows. So this is clearly a national movement, and I would just add that the science of traumatology as we understand it and delayed disclosure supports this legislation. Children take a lifetime to come forward. They suffer many disruptive neurodevelopments, impaired social, emotional, and cognitive issues. Their negative outcomes continue over a lifetime, whether it be substance abuse, depression, employability issues, increased risk of suicide, and these negative effects are enhanced by shame and anger and other things. I typically ask lawmakers, why should sexual predators be protected by the passage of time while victims suffer in perpetuity by the very silence that the perpetrator caused? The other final point I'd like to make is that changing these laws for child sexual abuse really shifts the cost away the cost of the abuse away from the victim and Hawaii to those who caused it. So I urge you to support this legislation. I'd be happy to answer any questions, and I thank you for your time.
Okay, thank you. Next up, we have the Hawaii Association for Justice in opposition. He was here for previous testimony, though. Okay, next up. Members, we have a number of individuals, mostly in support, 2 with comments. We have Cheryl Huck with comments.
Hello, can you see me? I'm not sure.
Yes, we can.
Okay, I support HB 2208 in the concept of expanding the statute of limitations and opposing all of these additional procedure requirements that you put on with your amendment in the last meeting. I've testified many times in front of this committee. In fact, most of you know my personal story. In the last 6 years, I've supported a bill like this that would extend those statutes of limitations. But in those 6 years, not one has passed. They've passed 3 times in the House and 3 times in the Senate. And each time they had some sort of little amendment like, oh, it's going to be effective now instead of 2060, or and it goes to special committee and it dies. So I have one additional story to tell you. I came to Hawaii, and most of you know I live in Michigan now, in December. I live in Michigan, right by Oxford, which is, you know or don't know, is where the shootings happened in the high school, and I'm a high school teacher. And I have PTSD because of the sexual abuse I had. And I'm home in Hawaii just to heal. No politics, no anything. And as I go home, I'm standing in the TSA pre-check line, and in front of me, we're all masked. I hear a voice, and it's a legislator, and I recognize that voice. And I said to the legislator, oh, are you so-and-so? And that person said yes. And she said, why are you here? And I said, I explained it, and she said, well, I thought your bill passed. Didn't it pass all those years? And I said, nope, it didn't pass. No, I know it passed. Nope, it died the last minute in special committee. And now it's come back, and now you're adding all of this stuff and causing more trauma to me and to the other people who I know have testified over the years. And I don't understand why we're even having this discussion when we've done the same thing for 6 years, and you do the same thing, it's on TV, and everybody's gonna pass it, and then in the very last moment, you don't want to make it effective immediately.
Ms. Hawk, it's been 2 minutes. If you could conclude your testimony,
I
please.
am done, but I hope that you will seriously consider it this year and actually have it pass without the new amendments. Thank you.
Thank you. Members, any questions? The board.
Yeah, the surrogate for Mililani Trask, are you still there?
Talbot.
Oh,
Yeah, here I am. Hi.
okay, my question to you through her or her through you is, you mentioned Kamehameha schools as if there were a lot standing out. Are there more that have not come forward? What percentage of the abused kids have come forward versus how many are still remaining out there?
Yes, thank you, Representative, for that question. First, I forgot to disclaim, not a disclaimer, but to be transparent. Mililani and I both attended the Kamehameha schools. And so we perhaps have a particularly impassioned view about this because we believe in the princess's legacy. But from that perspective, to answer your question first, when the legislature has passed the 2 window statutes with the group that went through and then the window closed, in that group, there were at least 32 plaintiff cases, 32 plaintiffs from Kamehameha School. That is a case that KS settled for $80 million. There were other 1 or 2 plaintiff cases involving KS students. Currently, we are now litigating all of the cases that were allowed when the second window closed. The majority of those cases are plaintiffs who are KS students. I hate to, we're very, very concerned because for some reason, particularly vulnerable students who were boarders at KS seem to have been the target of these predators and pedophiles. We can't explain how that happened, but that's the fact. And so again, to ask the question, if there's a problem, we're not aware of what the problem is, so we don't understand what this bill is with all these additional burdens and hurdles is trying to solve. And moreover, why are we importing almost verbatim California's law on this? We don't have the answers, but we're asking those questions.
So it's not about giving Kamehameha students who were abused more time because it looks like that issue is resolved or there's no need for more time, but it's about something other than that.
Well, well, on the one hand, we support expanding the statute of limitations. All of the testimony that you've heard, Honorable Representative, we support that concept because what is happening in this sort of flood of cases that have come in, these are adults who are starting maybe in 6th and 7th grade, who are now over 50. And because you all recognize that victims often don't even recognize what happened to them, they've been given the chance, and then this flood came in. So it's not so much to take care of whoever is out there, but what it is going forward is why are we placing additional burdens and hurdles on victims of child sexual abuse that we do not see with other tort litigants? We don't have an understanding about why that is. So it really has to do with a level playing field and being fair to everyone who wishes to pursue justice. I'm not sure that answers your question, but I can elaborate if it doesn't.
But thank you for that response, though. I appreciate that. Thank you, Vice Chair.
Thank you for your question.
Thank you. Members, any other questions? If not, we'll move on to HB 2444 HD1 relating to housing. We have 1 testifier today, Deepet, support.
Aloha, good afternoon. Chair Nakashima, Vice Chair Madayoshi, Denise Seri Matsubar for HHFDC. HHFDC stands strongly on its written testimony in support. This bill incentivizes the acceptance of the dedication of infrastructure for the city that the state is currently expending its housing funds out of DERF to pay for. Thank you very much. Happy to answer any questions.
Members, any questions? Okay, seeing none, we'll move on to HB 2495 HD1 relating to employment practices. First up, we have the Hawaii Civil Rights Commission in support.
Aloha Chair, Vice Chair, and members. Bill Hoshijo for the Hawaii Civil Rights Commission. The HCRC will stand on its written testimony in support.
Thank you. Next up, we have the Hawaii State Commission on the Status of Women in support. She was not here last time. Okay, not here still. AAUW of Hawaii in support.
Good afternoon. My name is Young-Hyo Lee. Chair Nakashima, Vice Chair Matayoshi, and members of the committee. I'm representing both AAUW of Hawaii as well as Democratic Women's Caucus here today. So you get two in one. You have our testimonies, and I'm here just to answer any questions you may have. Thank you.
Thank you. Members, any questions? Okay, seeing none, we'll move on to HB 2440 HD1 relating to public works. First up, we have DLIR with comments.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and House members. Joanne Fittenhard, Deputy from the Department of Labor. We stand on our written testimony with offering comments, and note that we met with the bill's proponent to discuss our comments with them. We thank you for this opportunity and are available for any questions.
Okay, thank you. Members, we also have a number of written testimonies from a number of unions, including HGEA, AFL-CIO, Operating Engineers Local 3, Nurses Union, and UPW. And late testimony in support by Pride at Work Hawaii. Members, any questions? Okay, seeing none, we'll move on to HB 1585 HD1 relating to emergency management. First up, we have the Department of Defense with comments.
Chair, Vice Chair, this is Luke Myers, the Administrator of the Hawaii Emergency Management Agency. We stand on our written testimony offering comments for HB 1585 and our bill for discussion necessary. Thank you.
Okay, thank you. And next we have Grassroots Institute of Hawaii with comments. Okay, not here. Members, any questions? Report.
Luke, question regarding what you made comments regarding not saying that we should do a Mother May I at the particular level of the county or not. What allows you to work most efficiently at Haima? And how does this bill affect you one way or the other, if at all?
Any changes to HR 127 impact state emergency management practices in mitigation, preparedness, response, and recovery? Coming out of the pandemic, obviously, there have been a lot of curveballs thrown at us, and this bill, like some others, makes some recommended changes. And we believe, based on the comments that we've provided, that those should be thoughtfully considered. Individual actions affecting Haima will eventually impact the services that we provide to the state.
So you want all the counties to touch base with you guys before they do something?
There's a time and a place in a traditional emergency management system. Emergencies start and end at the lowest possible level, which is at the counties in the state of Hawaii. We have seen during the pandemic and in very large scale extreme events that there may be a time when larger coordination is needed. The COVID-19 incident is one of those, and we may see more of those in the future, sir.
This goes back to Representative Herkes from the Big Island, who said we've got such a fractured system that we need a total centralized one. But now it seems like that may need some modification also, which I gather is why this bill is here. But the point is, will having to get the governor's approval to be in a county slow down some of this stuff, or are you guys efficiently affiliated a network where it's not going to slow down a county's response by doing a Mother May I at the state level?
Yeah, this bill specifically looks at some of the extreme situations. The county's authorities are still there for some of our normal and routine emergencies. So we believe that this represents an improvement as we come out of the pandemic, sir. We do not believe the system is broken. Emergency management has its roots in civil defense, which has been around for many decades. And again, we would support our counties and emergency management practices at the lowest possible level. If resources are not available or if there is larger prioritization needed, we would work with those counties, and this builds on that.
Okay, look, give me an example when the counties jumped out ahead of you and you need a bill like this to keep them back until they get permission. What's an example? Flood, hurricane, what?
So I don't think that there's a specific examples where the counties were out of ahead of the state. Usually you see clauses like this, and we see many of these now across the country coming out of the pandemic, when a local municipality, a city or county or a borough, depending on the type of state, where a county no longer has the resources to coordinate or function, the state has the right, depending on certain codes or legislation, to step in and support them. So it's not necessarily taking the rights away, it's more to help support. Obviously, the COVID-19 incident and what we have been faced with in larger statewide coordination and command has been a good example, and there are numerous functions during the various waves where this was exercised for this incident, sir.
Okay, I get it. I think you're referencing COVID-19 tells me exactly that this is, it's more about that than any other things that I mentioned in terms of floods or otherwise. Thank you very much, Luke, for what you do. Thank you, Vice Chair.
Members, any other questions? Okay, seeing none, we'll move on to HB 1979 HD1 relating to habitat conservation plans. First up, we have DLNR in support.
Yeah, good afternoon. David Smith, Administrator with the Division of Forestry and Wildlife, and we'll stand on our written testimony and support. And we offered some recommended changes just to get rid of some what would be redundant things in existing statute.
Yeah, thank you. That's all the testifiers we have for this measure, although we have a lot of individuals submitting written testimony in support. Members, any questions? Okay, seeing none, we'll move on to HB 2034 HD1 relating to the Hawaii Community Development Authority. First up, we have HCDA in support.
Hi, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. My name is Craig Nakamoto, and I'm testifying on behalf of Deepak Nipani, the Executive Director. We just stand on our testimony, written testimony in support, and just offer one small amendment, more of a housekeeping amendment. The language that is highlighted in our testimony seems to be extraneous, and as the bill already allows for some, holdovers, holdover members. So we'd ask that that language be just stricken from the bill as extraneous. Thank you.
Okay, thank you. Members, any questions?
Chair, I'm so sorry. With your indulgence, I want to request if we can go back to HB 1979. I just had a text come in right at that moment, and we went so quickly through testimony, I wasn't expecting it, but I did have questions.
Okay, let's finish up with this bill first. Members, any questions? Yeah, I do have one question for HCDA. For the area that you wanted deleted in your testimony, are you saying that that language would still be effectual because it is in another place in the statute?
Right, it allows it, correct. In another part of the bill, there's some holdover language that would help.
Okay, so this is just a pure housekeeping. This is not going to actually change the bill at all, except to make it a little clearer.
Clearer, correct.
Okay, thank you.
Thank you, Rep.
Okay, let's move back to HB 1979 HD1 relating to habitat conservation plans. Rep Lowen.
Thank you for DLNR. And I'm sorry, like I said, I was momentarily distracted, but was DLNR the only person testifying in person? Yes, okay. So for David, typically, like, what projects are getting an incidental take permit, or what types of projects do you expect have incidental take?
We have a number of different types of projects. It tends to be wind farms tend to take bass and seabirds. We have lighting, which takes endangered seabirds on Kauai. So various types of lights attract seabirds, and especially juvenile seabirds. We have power lines that take birds on Kauai. And but typically these projects will be wind farms. And one of the problems that we've had, and the reason that we wanted or we support having compelling people to get an HCP if there's a likelihood, is right now it's so voluntary that there's been wind farms that just haven't come in for HCPs. That, I mean, pretty much every wind farm takes bats and or birds. And then you got some out there that just aren't playing ball. And so I think it's, if you got a project that has a high likelihood of take, I think it probably should be compelled to come in and work with us.
Yeah. And like, what are the facilities? I mean, I know there was testimony from Hawaii Wildlife Center on Hawaii Island, but for birds and bats, like, are there separate facilities on each island? Are there, what are the facilities that would be used for services to treat them if they were treatable for the injured animals?
Yeah, if they're injured, then there's various ways to deal with it. It depends on who's permitted. So you need state and federal permits, and it kind of varies year to year. There's different veterinarians. Sometimes there's programs like the Save Our Shearwaters on Kauai. There's programs like the Hawaii Wildlife Center that are permitted and mobilized statewide. So there's different opportunities. We don't want to have something that's going to be a real burden, because we also support renewable energy, and we don't want to have an unreasonable burden on business. But we do think that they do need to come in and be responsible and work with us on permitting if there's a likelihood that they are taking animals.
Right. And of course, if there's an added cost because of it, it's everybody who pays an electric bill that ends up paying for it. But I guess the part I had the most questions about was the requirement for every person who has an incident, who's has this issue, to have a service contract with a provider for on-call emergency services.
Mm-hmm.
So I'm not sure what that means or how that requirement would be met. And it just seems like it could potentially be pretty costly, because as it stands in the bill right now, that provision has kind of no guardrails on it. Like what is the typical number of injuries? What is the cost per injury? And, where would this money be going? Specifically, if there's not real kind of like competition in the market for who gets this contract, then it seems like they could charge whatever they wanted. And maybe we should put some kind of parameters around that to link it to the number of injuries in the prior year. Or, I don't know what your thoughts are on that, or if you have any suggestions.
Yeah, from our written testimony, it says we support this addition as long as the rehabilitative care is expected as reasonable and practical. So you're right, it can get extremely expensive to the point where it just really doesn't make sense. And so in terms of providing care, the problem is before people would get an HCP permit, an animal would be injured and they would say, hey, we got our permit, so we don't have to deal with that injured animal. It just comes out in the wash already. And so they weren't dealing with it. I think if a project injures an animal, they should be responsible for seeing that it get cared for. We were able to set up programs on Oahu when I was the wildlife manager there with vets and whatnot that would help us out and work at just very low margins and very, very reasonable. There are ways to spend a whole lot of money on an individual animal. I'm not proposing that.
But right now, the way the bill is written, do you see that there's any kind of safeguards in it regarding costs to these projects that are affected? And I guess because the bill would be only prospective. It wouldn't apply to like any incidental take of projects that already are built. Although for energy projects, at some point when they would have to renegotiate their contracts, then this would apply to them.
Yeah, so I mean, the language I think that we're looking at is retrieve any injured, threatened or endangered species in a timely manner and provide emergency medical treatment. You know, so it's pretty wide open. We don't want to impose burdensome costs on businesses, but I think if they're operating a business and they injure an animal, we just think that it's reasonable that they be responsible enough to deal with that and not just say, oh, we already got.
No, I'm not disagreeing with you on that. I'm just saying,
Yeah.
do you agree there's nothing in the bill that kind of regulates what the limits of those costs could be, or kind of tying it to the actual costs of the number of injuries that occur per year, how many injuries that particular project might be responsible for? Like, there's nothing that links those two together, and just an open-ended requirement for an always available service contract to have on-call emergency services. I mean, who even provides those? We don't have any idea what the cost could be. It sounds like it could be quite a lot.
Yeah, you would have to be pretty careful about how you enter into an agreement with somebody. You don't want an open-ended cost agreement where you can be hit with a huge bill. And so you need to understand what it is you're getting into.
Okay. All right. Thank you.
Okay.
Okay, thank you. Members, we're going to move on to the last bill, HB 2135 HD1, relating to historic preservation reviews. First up, we have DHHL in support.
Aloha, Chair, Vice Chair, members of the committee. The department will stand on its written testimony in support, and we're happy to answer any questions.
Okay, thank you. And lastly, we have DLNR in support.
Aloha, Chair, Vice Chair, members of the committee. I'm Alan Downer, Administrator of the State Historic Preservation Division. The department stands on its written testimony in support.
Mr. Downer, we can't really understand what you're saying. I think he's, members, I think he's standing on his testimony in support.
Yeah.
We have two more written testimonies, one from the Society of Hawaiian Archaeology and one from the Historic Hawaii Foundation, both in opposition. Members, any questions on this bill? Okay, seeing none, we will recess for decision making.
Hawaii Affairs reconvening on Wednesday, February 23rd, 2022 to consider decision making on the 2 o'clock agenda. Okay, members, first up is House Bill 1768 related to the disposition of water rights. The bill already contains a defective effective date, and the chair's recommendation is that we move this as is. Members, any questions or comments? Okay, seeing none, Vice Chair, unamended.
Chair's recommendation is to pass HB 1768 HD2 as is. Chair and Vice Chair vote aye. Rep. Ichiyama?
Aye.
Rep. Kobayashi?
Aye.
Rep. Lopresti?
Aye.
Rep. Lowen?
Aye.
Rep. McKelvey?
Aye.
Rep. Nakamura?
Aye.
Rep. Takumi?
Aye.
Rep. Tokioka?
Aye.
Rep. Ward?
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much. HB 2084, House Draft 2, related to important agricultural lands. Members, on page 5, line 4 and 7, should be agricultural business plans also be subject to review. Also, technical amendments for clarity, consistency, and style. The bill does already contain a defective effective date. Chair's recommendation is to move it with amendments. Any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2084 HD2 with amendments known in the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 2169, House Draft 1, related to the Comprehensive Offender Reentry System. I will note the bill already contains a defective effective date. Chair's recommendation is to move this out as is. Members, any questions or comments? Not, Vice Chair, unamended.
Chair's recommendation is to pass HB 2169 HD1 as is, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 1486, House Draft 1, related to theft. The chair's recommendation is that we exclude mopeds from the scope of this bill. In the committee report, suggests a lesser penalty be considered given such as Class C regardless of value. The bill already contains a defective effective date. Chair's recommendation is to move it with those amendments. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1486 HD1 with amendments known in the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 1860, House Draft 1, related to catalytic converters. On page 11, line 12, the citation of 445-223 should be changed to 445-233. Other technical amendments needed for clarity, consistency, and style. Bill already contains a defective effective date. And also, Chair would like to note that the attempts to ship catalytic converters out of state should also be subject to the reporting requirements. And would like to make a note of those changes throughout the bill. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1860 HD1 with amendments noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 1434, House Draft 1, related to counties. Chair will note that the bill already contains a defective effective date. Chair's recommendations pass it as is. Members, any questions or comments?
Chair, sorry,
yeah. Representative McKelvey.
yeah, hey, I'm sorry about, I'm having some bandwidth issues. That's why I can't do my video on, but this is the non-judicial foreclosure bill. I'll be going with reservations and I'll save my comments for a final third reading.
Okay, thank you very much. Members, any questions or comments?
Chair, same request. Everybody deserves their day in court.
Okay, thank you. Anybody else, questions or comments? Not, Vice Chair, as is.
Chair's recommendation is pass HB 1434 HD1 as is, noting the reservations of Representatives McKelvey and Ward. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 2042, House Draft 1, related to solar energy. I'll note on page 3, line 8, the word "from" should be changed to "to." Bill already contains defective effective date, and Chair recommends also that we strike on page 3, lines 5 to 14, which is the cleaning of foliage. Members, any questions or comments?
I do.
Chair?
Representative Tokioka.
Thank you. I still have some concerns about this bill. So I know this is the last committee. I'll be voting with reservations. Thank you for the changes. Had you not made the changes, I would have been voting no, but thank you.
Okay, thank you very much. Members, any other questions or comments?
Chair, real quickly, Rep. McKelvey.
Representative McKelvey.
Yes, hi. No, I have some concerns too, insofar as the easement language goes and the effects that it could have, both of the Bureau conveyances and disclosure forms for real estate agents in sales. And so because of that, and just hopefully that can be looked at by the Senate, I'll just be going with WR.
Okay, thank you very much. Members, any other questions or comments? Representative Lopresti.
Reservations for the same reasons.
Okay, thank you. Representative Ward.
Same request.
Okay, reservations, Representative Ward. Members, any other questions, comments? Okay, seeing none, Vice Chair, as amended.
Chair's recommendation is pass HB 2042 HD1 with amendments, noting with reservations of Reps Lopresti, McKelvey, Tokioka, and Ward. Any other members voting with reservations? Any members voting no?
No for Kobayashi.
Rep. Kobayashi, no. Any other members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1891, House Draft 1, relate to the Uniform Recognition and Enforcement of Canadian Domestic Violence Protection Orders. Bill already contains a defective effective date. Chair's recommendation is that we move this as is. Members, any questions or comments? Seeing none, Vice Chair, unamended.
Chair's recommendation is to pass HB 1891 HD1 as is, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 2208, House Draft 1, related to the sexual abuse of minors. Note the bill already contains a defective effective date. Chair's recommendation is that we move this as is. Members, any questions or comments? Seeing none, Vice Chair, unamended.
Chair's recommendation is to pass HB 2208 HD1 as is, noting the presence of all members. Any members voting with reservations? Any members voting no?
No for Kobayashi.
No for Rep. Kobayashi. Any other members voting no? Chair, your recommendation is adopted.
Thank you very much. House Bill 2444, House Draft 1, related to housing. The bill already contains a defective effective date. Chair's recommendation is that we move this as is. Members, any questions or comments? Seeing none, Vice Chair unamended.
Chair's recommendation is to pass HB 2444 HD1 as is, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair recommendation is adopted.
Thank you very much. House Bill 2440, House Draft 1, related to Public Works. The bill already contains a defective effective date. Chair recommends also including the Department of Labor and Industrial Relations amendments. Any questions or comments, members? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2495 HD1 with amendments, noting the presence of all members. Any members voting with reservations? Any members voting no? The recommendation is adopted.
Okay, thank you very much. House Bill 1585, House Draft 1, related to emergency
Chair.
management. Oh, I'm sorry.
Excuse me, Chair. Are we on the right bill?
3440. Oh, I'm sorry. House Bill 2440 related to Public Works. The bill already contains a defective effective date. I thought I did this. And Department of Labor and Industrial Relations amendments. Members, any questions or comments? Seeing none, Vice Chair as amended.
The Chair's recommendation is to pass HB 2440 HD1 with amendments, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. The first, the last one was as is, right? Members, I think we need to reconsider 2495. Chair announced the wrong decision. Is there a motion to reconsider House Bill 2495?
Yes, so moved.
Okay. Is there a second?
Second.
Thank you. Members, all those in favor of reconsidering House Bill 2495, House Draft 1, please say aye.
Aye.
Okay.
Aye.
All those opposed? No opposed? Okay, thank you. So on House Bill 2495, House Draft 1 related to employment practices, the bill already contains a defective effective date. Chair's recommendations to pass that as is. Members, any questions or comments? Seeing none, Vice Chair as is.
Chair's recommendation is to pass HB 2495 HD1 as is, noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1585, House Draft 1 related to emergency management. Bill contains a defective effective date. Chair would like to include language in this with regard to the wildlife care, generally reasonable medical services or something to that effect. Members, any questions or comments?
Comment.
Representative Kobayashi.
So one of the problems here is that there is no specific prohibition for saying the governor can't just extend emergency proclamations every 60 days, as far as it looks like, unless we take action. So I'm a no vote on this. It's really not strong enough, given the abuse we've had on this already. Thank you.
Okay, thank you very much. Members, any other questions or comments? Seeing none, Vice Chair, I'm sorry.
1585 with amendments.
1585, management. think this one is as is. Yeah, I'm sorry. Yeah, I'm sorry, members. The amendment was for the next event bill. So House Bill 1885, recommendation of the chair is to pass it as is. Members, any questions or comments? Seeing none.
Chair, so
Vice
this is
Chair.
the one on the emergency powers.
It's 1585.
Yeah, I'm sorry.
Yeah, 1585 emergency powers.
So as is, unamended.
No, that's okay. Just want to note that our mayor called out the National Guard on his own. So there are real world situations why we need this bill. Just wanted to add that in there.
Okay. Members, any other questions or comments? If not, Vice Chair, as is.
The chair's recommendation is to pass HB 1585 HB1 as is, noting the no vote of Rep. Kobayashi. Any other no's or reservations? The chair, your recommendation is adopted.
Okay, thank you very much. House Bill 1979, House Draft 1 related to habitat conservation plans. On page 10, line 4, the reference should be changed to paragraph I. The bill already contains a defective effective date and so this is the one. Okay, so and then also on this one, I would like to add language to indicate generally reasonable medical services apply to injured wildlife. And the DLNR amendments. Members, any questions or comments?
Chair, were we going to add some additional provisions regarding the service contract?
Yes, I already mentioned that.
Oh, I'm sorry.
To clarify, Chair, I believe you're referring to page 10, lines 1 through 4, it's subsection J. And instead of a service agreement requiring some kind of reasonable medical services provided to any kind of injured animals. Is that right?
Yes, that is correct.
Okay, thank you.
Okay, members, any other questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 1979 HD1 with amendments noting the presence of all members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 2034, House Draft 1 related to the Hawaii Community Development Authority. I will note that on page 7, line 11, this needs to be amended to reflect the existing language in the statute that is being repealed, so that it is properly notated. Also, HCDA's amendments should be added. The bill already contains a defective effective date. Members, any questions or comments?
Question, comment.
Representative Kobayashi.
I actually like a comment. So basically what we're doing here is taking out community representation and replacing that with members selected by leaders of the Senate and the House. I think it'd be a better idea not to have membership decided by bodies whose public policy decisions are not sold to the highest bidder like we've seen recently. I'm a no on this.
Okay, thank you. Members, any other questions or comments? Okay, seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2034 HD1 with amendments. Any members voting with reservations? The rep board with reservations. Any other members voting with reservations? Noting the
I'll be going with reservations.
Rep McKelvey with reservations. Any other members voting with reservations? Okay, any members, noting the no vote of Rep Kobayashi, any other members voting no?
No vote.
No vote for Rep Tokioka. Any other members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. And finally, House Bill 2135, House Draft 1, relating to historic preservation reviews. On page 2, line 3, there should be a period after the word site in the repeal language. On page 2, line 12, the word officials should be changed to officers. On page 2, line 20, the word "and" should be inserted after the word officer. The bill already contains a defective effective date. The chair also recommends that we amend the bill to include a 5-year sunset so that we can revisit this issue. Members, any questions or comments?
Chair?
Yes, Representative
Chair.
McKelvey.
Yeah, I know. I appreciate your amendments that you're making with it, but I'm going to go WR because this could have a profound impact on the historic district of Lahaina. And unfortunately, while I appreciate the sunset, my fear is that the damage could be done, so to speak, insofar as losing some of these historical sites. So anyway, with reservations.
Okay, thank you. Members, any other questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2135 HD1 with amendments, noting the presence of all members. Any members voting and the reservations of Rep McKelvey. Any other members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much, members. We are adjourned.